There's a few things that you definitely can't control. You can't control taxes. You can't control the market. You can't control when your tenant wants to leave. But as a landlord, there are a number of things that are well within your control. Today we're going to talk about the 4 most important things in your control that are going to make the difference between success and failure. Let's get started. Really got to capitalize on the things that are the most in your control, because those are the things that are going to make you distinct, and they're the things that you can always concentrate on to make your business better. By focusing on these next 4 things, stick with me all the way to the end of this video, I guarantee you're going to get a much better result from each of your tenants. And the very first one of these has to do with an excellent product. If you are supplying to your tenants an excellent product in the way of your property, you're always going to be in the driver's seat. Too many landlords come to me and say, well, Ernie, I really don't want to put a whole lot of money into this until I start making money. I don't want to spend cash before I know this is going to be a profitable venture. Unfortunately, by not putting out an excellent product, you're not going to be able to demand the kinds of rents that your market will allow for. I mean, by putting out a subpar product, you're going to expect subpar results from your market. But by having an excellent product, you're going to be competitive with other landlords who are out there doing those same things. And if you want to attract better tenants, you're going to have to put out a better product. Additionally, and this is more on the practical side, by putting out an excellent product, you're going to be able to gauge more specifically any difference in how that product looks in the middle of the tenancy and at the end from what it looked like at the beginning. You may be asking, why is this terribly important? Well, let me talk to you from my experience about the condition and the way it changes over time. If you put out a product that has a few dents and scratches and scrapes, and then the tenant leaves and it's got a few more dents, scratches, and scrapes, guess what you're not able to prove to the court? Well, which ones were caused by you or were already there, and which ones were definitely caused by the tenant. But if you supply to the tenant a unit that is free of scratches and dents and scrapes, it's going to be a lot easier for you to demonstrate to the court damage that was caused by your tenant. I always strongly suggest to landlords that they need to be able to establish with very convincing evidence the condition of the property before it was in the tenant's possession and the condition of the property after it left the tenant's possession. Because without being able to show that drastic difference, you're never going to prove that in fact the damage that your property has currently was definitely caused by the tenant. Until then, it's very speculative. But by you being able to demonstrate this clearly either to a judge, but more specifically and more importantly to your tenant when it happens, you're likelier during the tenancy to be able to issue a bill to that tenant to restore the condition of your property back to that excellent condition. And so you want to start off with an excellent product to demand higher amounts from the market, but you also want to be able to establish during the tenancy even what the condition of the house was at the time they took possession, and how your intent is to maintain that condition throughout the tenancy. And if it turns out that a tenant leaves and harms your product, you want to be able to demonstrate to the court that your property was in a very specific condition before and is now in a different condition for which you should be compensated. So just like it's important for you to take control of the product that you put out on the market, you want to make sure that you have a great lease so that you are taking care of that product with a document that works for you so that you are the most profitable in your landlording business. Too many landlords come to me and have no idea what's actually in their lease. Time and time again, I read out terms of a lease that completely take landlords by surprise because either A, they never took the time to actually read their lease, Or B, if they did, they just didn't understand it well enough to be able to utilize the really good provisions that are in that lease. So it's not enough to just have a good lease. If you don't know what's in it, you certainly can't utilize the tools that are right there at your disposal. So I always dissuade landlords from simply going to Google and looking up landlord-tenant lease agreement. Because you really don't know, number one, is that lease appropriate for use in your state? Is that lease something that actually accomplishes your goals as a business person? And does this lease have all of the tools you're going to need if you're ever in front of a judge? If you can't answer those questions, there's no reason for you to choose that lease. You might need some guidance. And so where would you go for that kind of guidance? Well, another thing that I commonly recommend to landlords is a rule of 10. And so if you've got 1 or 2 rental properties, go find somebody who's got 10 or 20. Someone who does 10 times the kind of work that you're doing is going to have some life experience. It's going to be able to tell you what to avoid and what to do in order to prevent certain losses. One of those being, what's in a good lease? Again, when you're brand new to this, you have no idea what you just don't know. And I guarantee you, if you're at the beginning of this venture, it's a lot. And much of that has to do with whether or not you've actually got a good lease. So let's say you cover your bases and you get a mentor and they hand you a great lease. And so now you've got in your hands a powerful tool. The next step is understanding it. And so if you're at a point where you have in your possession a great lease, but you're not exactly sure how to use it, you're going to want to talk to a legal expert who can explain to you the pros and cons of the document you possess. One Texas example that I can show you is how late fees are regulated by the state of Texas, what you can and what you can't do. So in Texas, if you have a single family home, you're capped at 12% of the rent for a given month in late charges. So what's the best way to collect a maximum amount of the late charge so that it is a prohibitive amount, one that a tenant will not want to pay and therefore not repeat in terms of paying late so that they don't incur these charges? Well, the recommendation that I give to landlords is that you collect all of the maximum amount within the first 7 days. In Texas, you got to know what the law says. And the law says you can't begin to collect late fees until day 4. And so since you're capped at 12% of the state of Texas, I recommend that for each of day 4, 5, 6, and 7, you charge 3% of the rent. Here's an example. Let's say that rent for your unit is $1,000. To keep the math very simple, $1,000 means that on day 4, they're charged $30, and then another $30 on day 5, 6, and 7 for a total of $120, which in Texas is the maximum amount that you can charge for a single family home, barring other exceptions, but we're not going to get into all that. Generally speaking, it's 12%. If you know that within 7 days you can charge the maximum amount, that's the path or something like it that I strongly recommend. But you got to know what the law says, and you got to know where your limits exist. You got to know what makes sense for you. If you don't know, then you got to ask questions so that even if you have a great lease, you know how to use it. Another thing completely within your control is that like button. Give us a thumbs up if you are learning something new today. Leave us a question or a comment if you've got more. And if you're not a subscriber yet, why not consider subscribing? We appreciate that a lot. To really excel in the landlord business, it also helps to have a clear expectation for your tenants. And there's no better way to do this than by having a conversation with them at the beginning of the lease. You know, when someone doesn't know how to treat your property, it's hard for you to hold your expectation, which is trapped in your head, against them when they've never heard what it is that you actually expect out of them. Sometimes the lease just isn't enough. It helps often to have a set of house rules, and I always recommend this to all of my clients. You can have the base terms of a lease, but sometimes it helps to have house rules so that you clearly explain to your tenants what your expectations are in terms of things like, say, the loudness of gatherings, right? You don't want them to be too loud, and your HOA may have very specific regulations regarding music outside, how late it can be, that sort of thing. But what about how often to water the grass, or how often to mow the lawn, or what kinds of things can be left out on the patio? What kinds of things can be kept in the front yard? What about decorations or Christmas lights? What about how they tidy the home itself? You know, by having clear expectations, you can ensure that at the very least, your tenant is well informed as to what you expect to see whenever you do come for a visit. That being said, it's also important for you to establish to your tenant that you will visit. Even though there's not a repair for you to have to address, or even though they tell you, don't worry, everything is A-OK, no need to visit, you want to be on the property at least twice in a given 12-month period. But Ernie, if there's nothing for me to do, why would I show up? Well, too many landlords hand keys over to tenants and never look back until the keys come back at the end of the tenancy 2 or 3 years later, and then they are shocked to find out just how poorly the tenant managed the property. To prevent this, you need to be on the property at least twice. My recommendation is that you're there after 3 months and after 9 months. And by being there at these times during a 12-month period, you're going to ensure yourself of a couple of things. First, if you show up after 3 months and the place is a disaster, you know you need to come in and start issuing notices of default. If things are not being well maintained, or already things are being scraped and scratched and broken, you need to come in here and start making repairs. Make sure that it's very clear to your tenant that this is not acceptable, that any harm that's come to the property, they will pay for it exclusively for things that are broken from abnormal use or that exceed normal wear and tear. However, it's also important to be there at the end of month 9, because let's say you visited after 3 months and there were 0 problems. When you're there in month 9, if the place looks pretty good, in fact, if you say to yourself, this place is better than when I last had it, these guys are great. At that point, you need to start putting a plan in place to keep that tenant there. Whatever it takes, you want to be able to keep a tenant that's treating your property well in place. These are the best tenants. They are gold. And so by knowing these tidbits about them, you can plan early and maybe get them to commit to another 12 months. So not only they have a great place to live, but you've got a great tenant in place. But Ernie, what am I looking for when I'm there? Well, you're looking to make sure that all of the expectations that you laid out for your tenant are met. Are they reporting, for example, problems with the unit in a timely manner? Common one is the leak from the ceiling. If you show up and notice something that they never noticed, they're not keeping a watchful eye, and that's ultimately something that could cost you money. Additionally, are they changing out the air filters for the air conditioning unit? If they're not, be prepared to do that yourself, and be prepared to reinforce the absolute necessity for the tenant to do this if that's in your list of expectations. How is the yard being maintained? Is there Crayola writing all over the walls? Whatever's happening that's causing your property harm, make sure it's addressed, particularly with written notice, and then make sure that it's corrected quickly. Finally, you want to be able to come to a clean finish whenever a tenancy has simply come to an end, or whenever you need to make that happen. You see, most of the leases that are out there have an automatic renewal, so that even if the first 12 months have elapsed, if either the landlord or the tenant have not sent notice in writing to the other party saying, at the end of this lease, it's over, everything's done, then generally speaking, a lease will lapse into a month-to-month tenancy. Now, personally, I don't like this arrangement. If you're going to keep someone, you ought to have them locked in to a year term, or whatever term you're comfortable with, the month-to-month tenancy is too speculative and doesn't secure you in the event that the tenant simply decides they want to go. However, if it's a matter where you have made the decision that they have to go, make sure that you know how to do that correctly. One thing that landlords get wrong a lot is not knowing how many days are required by state law and by their lease in order to terminate a lease properly. Too many landlords just presume that a reasonable amount of time is okay. Couple of weeks should be enough. I sent them a 2-week notice. They haven't left, and now I want to proceed with eviction. Well, we know, for example, in the state of Texas, that the minimum number of days that you can give any tenant is 30 days. And so if you have failed to give at least 30 days notice, there's no way that you have properly terminated your month-to-month lease or brought a lease that requires termination to an actual end. By not doing that, you set yourself up, not just to be turned away from the eviction court, but to be at the receiving end of an order or a judgment against you for having done something illegal in the courts and causing harm to your tenant. Additionally, some leases require more than just the minimum 30 days. There are leases out there that sometimes require 45 or even 60 days written notice in advance in order to properly terminate a lease. Now, what this doesn't mean is that any 60 days during the tenancy upon notice mean the whole thing is over. What it does mean is that once the tenancy has come to an end, you can terminate the lease as long as 60 days prior to that date, you've given written notice. So that if you've lapsed into a month-to-month tenancy, that tenancy technically ends 30 days later. But to make it effective, if your lease requires 60 days of notice, you're going to have to give as many as 60 days before that month-to-month tenancy comes to an end. If you're in the middle of it, you're looking at 2 more months at least because of the requirement in your lease. By not knowing this, you're likely going to spend time or spend money that you otherwise wouldn't have had to if you had just known precisely what your lease actually said. By knowing how to bring your lease to a clean conclusion, you're going to set yourself up for maximum gain. Maybe you've got a new tenant who's willing to pay a much higher rent, and you've got an old tenant locked into a current rate, and they're not willing to pay that higher rate. Guess what? You're not stuck with that tenant unless you don't know how to bring your lease to a clean finish. By knowing how to close the chapter on a lease, you're going to be better off, and you're going to optimize your profitability in your landlording business. You may be in a state that requires something else. Make sure you are aware of what your state requires in order for you to bring your lease to an end. Some states require cause. Texas is not one of those states, and many other states do not require cause, but they probably do require a very specific amount of notice. You need to educate yourself and find out what that is, and make sure you are in compliance with your state's law and with the requirements of your written lease. I hope you found today's video helpful. I hope that you're able to utilize these tips in order to improve your landlording business. I know that YouTube seems to think that this video right here is the next best thing that you should watch. Watch it along with all the other content on this channel. And until next time, landlords, happy leasing.